Well, if you are working in the United States on an H-1B visa, there is one question that you should ask yourself today. How well do you really know your employer? Most people carefully read these salary packages, job titles, and office location before accepting an offer. But you know what? Very few check whether the company sponsoring their visa has a clean legal record or not. And that particular mistake could prove extremely costly because the US government has now taken strict action against several employers accused of violating the H-1B rules. The US Department of Labor has updated its official list of employers that have been debarred from the H-1B program. Let me simplify this for you. These companies have been barred from sponsoring a new H-1B worker because authorities found serious violation of labor and immigration law. Well, this is one of the strongest action the government has taken against an employer under the H-1B system here. Ladies and gentlemen, according to the latest update, 4 companies have been placed on this particular debarment list here. They include GowraTech, Renotek, Seeloz, and Sherwood at Mount Dera, operating as Sherwood Academy now. While these companies have been prohibited from filing new H-1B petition for waiting period after federal authorities found significant compliance failure. Now, here's a question many Indians are asking. What happens if you already work for one of these companies? So the answer is very important. Your H-1B visa does not automatically becomes invalid overnight. However, your future immigration journey, it can become much more difficult. Well, a debarred employer cannot file an H-1B extension when your current visa expires. It cannot sponsor changes to your employment. It also cannot move forward with certain employment-based immigration processes, including the future green card sponsorship in many cases. So that means an employee who has done absolutely nothing wrong may suddenly find themselves in a difficult position simply because their employer failed to follow the rule. Can you imagine working hard for years, building your career, paying the taxes and following every immigration rule, only to discover that your company's legal problems are now affecting your own future? Well, it is a situation no professional wants to face these days. Well, the government's message is becoming increasingly clear. Companies hiring foreign workers are expected to follow every requirement under the H-1B program. If they fail to pay proper wages, submit incorrect information, or violate labor regulations, they can lose the privilege of sponsoring foreign talent. American authorities are making it clear that immigration compliance is no longer something companies can take lightly. So you know what an H-1B worker should do? The first step is awareness. Before joining a new employer, verify its reputation and compliance history. If you're planning an H-1B transfer, make sure the sponsoring company is eligible to file your petition. A good salary and an attractive job title, it means very little if the employer cannot legally support your immigration status in near future. Well, this development also highlights much bigger trend here. The US is not simply checking visa applications anymore. It is also carefully examining the companies that bring the foreign talent into the country. Employers are now under the microscope just as much as employees are. And as enforcement becomes stricter, choosing the right employer, it may also become just as important as getting an H-1B visa itself.